Good evening, everyone. I am so glad you guys are here for it again. Thank you so much. I appreciate every single last one of you guys for being here. Again, we're here for another reading, reenactment of the Tasha K. Key testimony from the case of Cardi B versus Tasha K. Defamation slander trial. This is the day I've been waiting for, y'all. This is the day when we hear about Tasha K's invisible attorney called Mimi. Now, I've been waiting for this day, so I'm so glad you guys. I want you guys to share this live. I want you to click, I want you to share, I want you to like it and subscribe if you don't mind, because we're going to keep bringing you more of this type of stuff. Without further ado, let me introduce my cast. First up is our own court deputy, Miss Powerful. Hello, Miss Powerful. How are you?
Hello, everyone. Hello, everyone.
All right. Next, we're going to have our I have two Tasha K's today. Okay, so what we're gonna do, we're gonna go over to our attorneys. First, we're gonna have Olga slash Mr. Sabak, played by Miss Dennis.
Good evening.
Hello.
Good evening.
Good evening. All right, next we're gonna have our other set of attorneys, which is going to be our Cardi B's attorneys, Miss Motts and Miss Moore, played by Miss Purple Couch. Hello, Purple Couch.
Hello, hello.
Hi.
How are you?
I'm doing wonderful. All right. All right, young people, wonderful people. Next, we're going to have our sitting judge, played by our own Melly Mel. Hey, Mel.
Hey, how's everybody doing?
All right. Last but not least, we got our two Tasha K's. We got a new one tonight, played by our old R. Kelly judge, but now we have our sitting, residing Tasha K. Here we go, played by Rhoda. Hello, Rhoda.
Hey.
And of course, our normal Tasha K, which is played by Perspective, me. Hey,
Hello.
Perspective. All right,
Hello,
so
hello.
the first half is going to be played by Rhoda, and the next half is going to be played by Perspective Me. All right, guys, you guys ready? We're going to start from first page, guys. You guys ready? Everybody ready?
Yep,
Yeah.
we ready.
We're starting at page
All right.
4.
Yeah, whatever the first page is. Yeah, first page is for
Okay.
rock and roll, guys. And we have Mr. Our sitting journalist, Mr. Dennis Byron, is in the house. Hey, Dennis. Hip Hop Inquirer. All right, guys, we're ready. Let's go ahead and get rock. Oh, I do want to state, guys, let's curtail some of the laughters because we have some professionals looking at us tonight. Because we want all the information to be put out there tonight. Okay, guys? All right, let's go.
Friday morning session, January 21st, 2022, 9 a.m. proceedings. All rise. United States District Court of the Northern District of Georgia, Atlanta Division is now in session. Judge William M. Ray II presiding.
All right. Thank you, sir.
Please be seated and come to order.
All right. So you should have a copy of what we proposed, which is part based in part on what y'all have proposed. So let me just start, as I indicated yesterday, start with the plaintiff and let's first talk about what I didn't give you that you requested and you believe should be in there.
Thank you, Your Honor. First of all, I just wanted to thank you and the court staff for the time you've put into it. Obviously, with these jury instructions, it's a big endeavor, and it's obvious that you guys put a lot of work into it. So we really appreciate that. As far as the categories that we feel like have been excluded or would, I guess, accurately fit into that bucket, We had proposed, I guess, a couple of days ago, in addition to the alter ego charge, just adding one additional sentence that was directly from basically the same case citation, just making clear that the president of a company is presumed to be its alter ego, but no such presumption exists in favor of any other official of the company.
Hold on just a minute. In the court's version of instructions, where is alter ego?
It is, Your Honor, on page 9. The case citation there is Sims versus Millers.
I'm just comparing right now. So what is the testimony as to Miss Keeby's position with Keeby Studios? I know she's the face of it, and I'm sure she testified about what her position was.
Your Honor, Miss Keeby testified when she was on the stand that her husband was the president. And then when Mr. Keeby was on the stand, we asked him about that. And his testimony was that both he and his wife are the president of the company.
Is that a legal possibility? I mean, for two people to share the same role as president in an LLC under Georgia law?
Well, I mean, Your Honor, it's hard to argue about what is legally possible in this situation because we don't have really any meaningful distinction between the individuals and the company. So,
What do you mean?
meaning that there's no operating agreement, there's no corporate resolution, there's nothing that establishes that they have some formal title in the sense that, Your Honor, as I understand Your Honor's question, it really boils down to how they testified and what their own subjective belief is about their role within the company. And they both testified, or rather, she testified that he's the president, and he testified that the two of them are the president.
Yeah, but my question is more focused on what Georgia law permits. Does the record reflect that this is a Georgia LLC?
It is a Georgia LLC, Your Honor.
Does Georgia law have any requirements that would negate the possibility that two people could serve as president at the same time?
I'm certainly not aware of any, Your Honor.
Do you know what the code section is under Georgia law for LLCs?
Let me see if I can find it.
Okay, 142840, dealing with corporations, partnerships, and associations. So maybe that's it. 840 is required officers. Anything else that you want to say about this particular charge?
No, Your Honor. We believe that the addition that we requested is consistent with the law. And so, to the extent the facts support that, then we believe it was.
Well, I kind of want to, I guess what I'd ask is whoever's going to speak for the defendant when we're to pull the microphone close to you, because I don't want y'all switching back and forth. That would be too time consuming. What's the defendant's response to the request that be added to the instruction?
Your Honor, I didn't hear what the sentence was. I'm sorry.
I'm sorry?
I couldn't hear what the sentence.
If you go to page 9 of our instructions, of my instructions, the alter ego instruction is the first instruction at the top of the page. And the addition that the plaintiff asks for is this, quote, the president of a company is presumed to be its alter ego, but no such presumption exists in favor of any other official of the company. So I guess it really, it's rebuttable presumption, I suppose. It doesn't say otherwise. Maybe you check that statement is in the case cited?
I don't really have any objection to it. I don't really think it's necessary because I believe that the court's charge already covers that. I mean, basically the sentence before then to me sounds like it's saying the same thing, but I don't necessarily have an objection to that additional sentence.
The sentence before? I'm going to add the statement then as requested. I mean, the honest truth, I think ultimately it's not really going to matter. If the jury decides that the plaintiff was defamed and damaged, I can't imagine that the company is not going to be held responsible because it was the company's business that Ms. Keeby engaged in. When she was questioned about finances, she stated she didn't even know that was her husband's responsibility and his role on behalf of the company, whether the profits made, the ad revenues derived to the benefit of the company, maybe ultimately to the members of the LLC. But, the LLC is a legal being just like a corporation is. So I don't think the addition of the instruction is going to necessarily make the case any stronger for the plaintiff, because it's going to, in my mind, depend on whether or not the plaintiff wins her defamation claim in the abstract, not necessarily as to whom. I mean, Mr. Keeby has no liability here. There's no allegations against him specifically, so his liability would only be derivative of his ownership interest in the LLC. So I'm going to add that request to the charge. All right, your next issue, sir.
Yeah, so Your Honor, our plaintiff's request to charge number 22 was an additional charge related to actual malice.
Hold on a second. Let me catch up with you.
If you have the joint proposed charges, it is on page 32, request to charge number 22.
All right, go ahead.
So, Your Honor, it's our position, obviously, that this is a fair statement of the law. If Your Honor has not included it simply because you believe that the actual malice charge that is included is sufficient and this additional charge is unnecessary, we're fine with that. And simply arguing this is a relative factor for purposes of finding actual malice when we argue to the jury. But I just wanted to clarify that to make it clear that this wasn't included as an indication the court believes this is not a fair statement of the law.
Give me a second to look at that case.
I'm sorry.
Give me a second to look at that case, all right? So hold on a second.
Brief pause.
And this comment might apply to other charges of either party that I did not include. It is not an incorrect statement of the law, but it's also not necessarily a jury instruction. And this is a pretty old case, 1931 case. Opinions were written differently then they are today. So they're a little less clear because they're almost dating back to that period of time. Put on my reading glasses here. Let's see. At that time, cases were written in very abstract kind of formation, which basically principles of law were just sort of laid out. I think the issue in that case is whether there was sufficient evidence in the record to establish malice, and the court points to something that could be actual malice, and that is, you were told that it was incorrect. I suppose there was no evidence that whatever statements were made were correct, and then you refused to retract what you had said. And, having served on an appellate court, I certainly understand that oftentimes appellate courts comments about the evidence as it happens to appear in the record to say that certain elements of whatever the charge was, tort, contract, whatever, are met and point to the evidence that could have satisfied that. But I don't think it's necessary to give that charge that you've requested. To me, that's really just more of a function of argument. And should the jury find in your favor as to malice, then certainly the fact that there were demands made to retract or cease and desist, the defamation that went unheeded, would prove sufficient evidence for the appellate court to affirm the decision that the jury makes. And I recognize that, we spent a good bit of time yesterday. And we may not yet be finished with that, arguing about whether or not retractions were received, demand for retractions or cessation of defaming conduct was received by defendant. But assuming that the jury has sufficient evidence, which I think they do, to conclude that these demands were made, then the continued defaming statements that the defendant allegedly made would provide that necessary. So I'm going to give that instruction, but that's my explanation.
Thank you, Your Honor.
All right.
Our plaintiff's request to charge number 29 on page 40.
29, all right.
And this, Your Honor, we have a similar view about this. Obviously, our position is this is a correct statement of the law, but to the extent this was not included simply because Your Honor believes that the prior instructions are sufficient, then, we're comfortable with that. But certainly the totality of the conduct, and, for example, there's many cases that deal with intentional infliction of emotional distress and how a factor that you would consider in determining whether something is extreme and outrageous is whether, it's repetitive and continues over a period of time. So that's all we were trying to address with this instruction. But, again, similar to the previous one, we're comfortable making that sort of argument to the jury.
Yeah, I think a similar analysis for me that this principle of law can be used by the appellate court to affirm the decision that a jury might make that there was intentional infliction of emotional distress. But I don't think it's necessary as an instruction. And I'm very wary of how instructions that seem to direct jurors in one direction or another. So I'm not going to give that instruction. I do want to just make this basic comment about the intentional infliction claim. I'm really conflicted about that claim anyway, and I don't really think it's necessary in the case because I can't imagine that the jury would make a decision that there was an intentional infliction of emotional distress and that the plaintiff was damaged but not find that there was defamation or invasion of privacy. And so, it's an additional charge, but probably the hardest charge to sustain on appeal in Georgia courts. There's just not that many cases that you can look to with Georgia appellate courts have found behavior to satisfy this tort. It almost seems to me under Georgia law that it is a tort that was created in common law with nothing else when nothing else quite worked, but the behavior, of course, was just so bad that it could not go unpunished. The Georgia courts have been really reluctant to appellate decisions to allow the intentional infliction claim to apply to normal, ordinary situations that might occur because they expect it to be rare. But that's sort of an aside from this analysis generally. I think the instruction that it's in the record or the proposed charges is sufficient on this charge or on this principle, the tort principle. And so I'm not going to add this. Thank you, though.
Thank you, Your Honor. The next one was our plaintiff's request to charge number 39 on page 50. And this charge dealing with damages that are inferred for defamation per se overlaps with some of the issues we have with certain language in that particular charge. But the big issue here, as we see it, is that the type of damages that are potentially recoverable for defamation per se are broader than the other categories that we specifically enumerated. So we have mental pain and suffering. We have medical expenses, but in a defamation case, harm reputation is often considered sort of a primary harm caused by defamation. So we've never alleged that there are special damages with respect to harm reputation, but we have always maintained,
What about the special damages associated with?
meaning like we haven't tried to put a number on any specific harm related to reputational harm. But we've always contended in this case that the jury is entitled for damages for defamation per se to find that there are certain damages to the.
Okay, general damages? I mean, special damages by nature are damages that are provable as to the amount, like Dr. Sherry's expenses that she charged. There could be other expenses I'm missing in my mind right now. General damages are everything else. I guess my problem is that I don't quite understand what the standard for calculating those damages would be for the jury, other than enlightened conscious of the jury. And there's no way to, well, let me put it this way. There's certainly no evidence of reputational harm to any type of mathematical calculation. For example, there's no economist that has come in or record music expert who's come in and testified, and whether or not they could testify under Dubart would be another question, but that testified that the plaintiff's career has been harmed in some measurable degree. I've seen that before. There was a case before the Georgia Court of Appeals where an athlete at Auburn University who was involved in a wreck was an Olympic world-class athlete who was hurt in a car wreck and not his fault. And there was evidence brought in about what earnings he had lost the opportunity for and likely would have achieved had he not been injured. We don't have anything like that here. And that case got reversed, but for a different reason, not because of the expert's testimony, but because the trial judge did not allow the defendant an opportunity to bring in its own economic analysis based on some strict adherence to a pretrial order that didn't include that. And I won't bore you with the details. But in any event, we don't have any economic evidence here. And so really, we're left with this enlightened conscience, I guess, right?
Right. That's right, Your Honor. And the issue that we have, so maybe it's just helpful for me to explain what we had in mind with this charge. So the idea was we had medical expenses. We have medical pain and suffering, which is, there are separate instructions for that. And then we had sort of this catch-all category that would include reputational harm that the jury could award with respect to defamation per se. And we made clear in this instruction that the jury should not award duplicative damages. So, in other words, if you've already ordered or awarded damages in these other categories, don't also award it in this category. And so we're not necessarily wedded to this charge per se, but the issue is that the way that the current instructions are framed and the verdict form that goes with it, there's no category that will allow for the jury to award those other types of damages. Now, the verdict form as proposed only has a line item for medical pain and suffering and for medical expenses. It doesn't allow for the it doesn't allow the jury to award these additional damages that are plainly recoverable for defamation per se.
Yeah, that can be on the verdict form, can be taken care of by just more generalizing the pain and suffering category into several or into general damages, parenthesis, i.e., pain and suffering, reputational harm, etc., and make that a very broad category. I understand your point about the verdict form because reputational damage would not be pain and suffering necessarily.
I mean, I guess, Your Honor, I still say that.
Let me do this. Give me just a second to read. I'm reading page 12 of the proposed instructions, and I just want to read what I've got here about them.
There's a brief pause.
So, what if this? I know you like what you wrote, but what if on page 13 of the proposed instructions, in the middle of the page, it says the plaintiff seeks damage for mental pain and suffering? That was edited to say for mental pain and suffering and reputational damage and damage to her reputation, and then everything else is left the same. In making such award, your standard should be your enlightened conscience as impartial jurors. Questions of whether how much, how long the plaintiff has suffered or will suffer because of reputational damage, the plaintiff suffers from that. And so I think that's still generic. Uh, are, are for you to decide. We're talking about an enlightened conscience for this type of damage anyway.
Yeah, I guess, Your Honor. I would respectfully submit that some of the language that follows that paragraph is not really directly applicable to the reputational harm. So I think that, maybe the easier course of action would just be to add a separate sentence after the pain and suffering in the future, or just making clear that they can also award for that reputational harm. And then we just include a line item for that in the verdict form.
That's on the next page.
Yeah, so the very first paragraph of the next page, it talks about pain and suffering in the future. And just after that paragraph, have a sentence that would be to the effect of, you may also award.
Well, would it be your position that the plaintiff is not only entitled to recover for any damage to her reputation that has occurred today, but also damage that continues to occur to her as a result of the statements previously made?
Yes, Your Honor, that's a fair point.
I mean, the internet stuff never goes away, does it? People can take down what they put up, but they can't take down what other people have shared or put maybe the sharing links back to the original listing. And I'm not sure that we really have evidence of that here. But I've always told my kids when they were younger, and they're all grown now, but assume that what you put on the internet is going to be there forever because it seems like it always is. I know this, and some of this is pre-digital age, but when I was going through the confirmation process for this job, the Department of Justice attorneys that were vetting me and preparing me for confirmation, they referred to this generically as the Wayback Machine. But they went back and found articles written about me when I was a legislator, things that I had said in debates that I couldn't find. And then I had to explain them, because I had to disclose them to the Senate Judiciary Committee. And this was the pre-digital age, but everything has been scanned and placed on record and available. So I would think that to the extent that the jury were to determine that the plaintiff has been defamed and that she has been harmed, her reputation has been harmed, the jury may also find that there is going to continue to be that type of harm. And so they're not simply compensating her for the harm she suffered today, but the harm that might continue to occur. But granted, nobody really nobody has really given me a case that says that, but it just seems intuitive to me that that can happen.
Yes, Your Honor. I think your proposal will work. Obviously, provided we modify the verdict form accordingly. I guess the only thing I'm still maybe a little hung up on is just these factors at the bottom of page 13 that don't necessarily seem to apply. But I think a semantics issue.
Okay, let me ask the defendant what the defendant's position. What's the defendant's position about the discussion on the damages?
Yes, sir. Thank you. We would object to the plaintiff's request number 39. We believe that the court's charge is sufficient to explain the general damages and the type of damages the jury can award. And additionally, I don't believe that there was any evidence about damage to the plaintiff's reputation. So I'm not really sure why that would be highlighted all throughout the jury charge when there was no evidence as far as what the court already said. There's no evidence of monetary damage or damage to business contracts or lost revenue or anything like that. So I feel like including that in the jury charge would just be confusing.
Isn't that what is presumed, though, when you make statements that are liable per se, is that there's that kind of damage too?
Right. And I believe that the court's charge does cover the general damages, sufficiently.
Point to where your point is covered.
Yes, sir.
We're on page 13.
Starting on the bottom of page 12, where you just say damages are given as compensation for an injury done, and generally the injury is the measure when the damages are of a character to be established in money. And then going to page 13, if the injury is small or mitigating circumstances are strong, only nominal damages are given. And then the next paragraph is, proper amount of nominal damages is a question to decide under all the facts and circumstances in the case. I believe that covers any potential, because if there is any damage reputation, it would be nominal. So we do not have any evidence of specific monetary damages.
All right. So let me use a really bad example here, because it might be that the harm that occurred to his career was justified based on the alleged conduct. But take Kevin Spacey, for example. Allegations came out about him and sexual misconduct. I don't think it would be fair to say that if those allegations were untrue, and I have no evidence to suggest, and I'm not suggesting that they were untrue, but that the harm that was suffered to his career was nominal. I mean, it was probably fatal. And that very well may be the case for many actors who are accused of that kind of behavior. It's really hard to know, I suppose, but we do know what? We do know what the current tide is. And the current tide in the whole, quote, cancel culture, close quote, terminology that exists in the industry specifically, and it may be broader in that industry, is that that type of reputational harm may be long-standing and more than mere nominal. I agree that we don't really have any testimony from any industry individuals that would say that the plaintiff's employability is harmed. In fact, the plaintiff's career is probably based on her own testimony about all the things that she's currently engaged in, including the fact that she just recently hosted a major music award show, is that it's now as robust as it's ever been. But, the jury might conclude based on the statements that have been made and said is that there has been some damage, that maybe her career could have been hit at a higher level at this point had this not occurred. I mean, it's one of the reasons I asked about why, whether videos were going to be played of her performances generally, because I thought, to the extent that she has some very provocative songs and videos, that one might make the argument that these allegations, even if untrue, really doesn't harm her because, the subject matter of a lot of her music, is so edgy. I'm trying to pick my words really carefully here, as you might imagine. But to me, that's more of a strategic decision, I suppose, that you make. I don't know. I don't know that I can say that the jury would be unauthorized based on simply their decision that these remarks that were made about her were slanderous. That means that the jury is making a decision that they were also bad. I mean, it's not like she was being accused of being a good person in it. And generally speaking, taking the plaintiff out of it, these kind of remarks would be very damaging to someone. Defendant can certainly argue that. well, not damaging to this person, but maybe damaging to each individual juror if it was about them. But that's not who they were about. So that again goes back to what you can argue. But in the abstract, it's harder for me to say that there's not some evidence to the jury. I mean, the jury might disagree. They might say, yeah, this is going to harm anybody. Uh, One of the things that the jury instructions often do, and I don't know that there's a pattern instruction in federal court. I haven't seen if there is one there, but state court in Georgia there is. So, you tell the jurors they can or they're able to use their common sense. Some people might argue that common sense is when you say things like, or say things about anyone that it would harm them. So I guess ultimately, here's where I'm going to go. I want a little bit of time to think about this and talk with Mr. Roberts about it. And if I supplement the instructions, I will probably supplement them in the context of what I've already done as opposed to the plaintiff's request as a standalone instruction, because I think it should be incorporated generally. And the discussion of the damages, I'm gonna leave that as they are. So I've written a star beside this area of the proposed instructions, and I'll come back to it later after we're finished today, after we're finished this morning.
Thank you, Your Honor.
Thank you, Your Honor.
All right. Anything else from the plaintiff?
I think that's all I have in terms of things we're taking out. Obviously, we have some additional.
Well, go ahead and talk about things that you don't like that are in there too, and then we'll swap off.
Okay, so Your Honor, starting on page 6,
Okay.
just in the second paragraph where it refers to infidelity, we just proposed changing that to adultery simply because, Your Honor, and I will get to this in a second, but since Your Honor is putting the per se categories to the jury, adultery is actually a crime in Georgia. So we're just proposing to change that to match the crime.
Any objection from the defendant, infidelity to adultery?
No, not really. I don't think it matters.
Really, it's just to make it consistent.
It's also law in a state, and I don't remember what state it was. Let me just make sure I know how to spell adultery. Does it have an E in it or not? I think it doesn't. Okay, so it does have an E. Okay. Which this was the case when I was in law school. I took a class on legislation from a fairly famous for University of Georgia Law School, a professor named Santel, who died a few years ago. He was our version of John Houseman of the paper chase. He was a very sociocratic, very no nonsense professor. But there were a couple of classes that he taught torts. But there were a couple of classes he taught for upper level students that were a lot of fun, and legislation was one of those classes. I was lucky enough not to have him for torts, but I took him for this class, and he would highlight every day crazy statutes that still existed on the books. And I think he said this was Louisiana, that in Louisiana that it was illegal to do anything to disturb or bother a squirrel. Now, I doubt anybody has been prosecuted for that. And I know that no one has ever been prosecuted for adultery in Georgia for years and years, and it probably would be deemed to be an unconstitutional statute today. But y'all agree on the issue of the term, so I'll put it in there. I personally think infidelity is probably a more offensive term because while that's not illegal either, it's just kind of how we think of it generally. But I'll use adultery if that's what you want. All right, anything else?
Yes. So on page 7, Your Honor, the section that's based off of the Jellet decision dealing with rhetorical hyperbole and opinion,
I'm sorry, what page?
page 7.
Okay.
Yes, I'm with you.
Okay, so the first issue, Your Honor, so if you read the first sentence there, it refers, there's the clause, because their factual premises are revealed. Is not, well, the part because this factual premises are revealed, that subclause really only refers to the pure opinion part of this. And really, the rest of this paragraph only refers to this discussion about opinion. So if you actually look at the decisions, while it's sort of in the decision written in this order, the rhetorical hyperbole is actually an entirely separate issue. Your Honor,
How would you define rhetorical hyperbole?
excuse me. So I don't know if there's a great definition for it, but Your Honor, An example would be, for example, the case that the defendants actually cited in support of their charge, which was the statement was made that an attorney had torpedoed his client's case. And so the issue was rhetorical hyperbole, is that obviously it can't be taken literally. He wasn't saying he actually torpedoed his case, but when you interpret it as it would reasonably be understood by anybody reading that statement, that just becomes the statement that you evaluate for purposes of defamation. In other words, something equivalent to like he, severely harmed his client's case would be the sort of the literal interpretation of that hyperbole. That statement then becomes, the statement that's evaluated for purposes of defamation. I don't know that I can't think of any scenario where we actually have that at issue in this case, but even if it were at issue, defendants are still capable of arguing that statement is, wasn't intended as a statement of fact, that it's merely hyperbole. Um, I just don't believe that including it as part of this section, as it's worded, is accurate or helpful to the jury in resolving that issue.
So are you arguing that there is nothing that was said by defendant that could be considered to be rhetorical? I mean, I'm not sure if this is hyperbole, but, and I'm just looking up that term on the internet, but are you saying that nothing that she said could be construed as that?
I'm saying I don't interpret any of the statements that are at issue to be hyperbole, at least by my recollection. But actually, the more fundamental issue is that even if rhetorical hyperbole was squarely at issue, what I'm suggesting is that this is not the way to address that issue. This paragraph dealing with, when facts are disclosed as part of the overall communication really has nothing to do with rhetorical hyperbole. So if that were a charge that we were really dealing with or the need for, it would need to be worded in an entirely different way in a different context.
I'm really not following your objection. This is, I think, a correct statement of law generally, isn't it?
No, actually, so Your Honor, maybe it would be
I mean, it's a pretty recent case.
right. This quote actually is not a fair representation of what's in the case, is what I'm saying. So it may be easier to talk about the opinion issue first and then circle back to rhetorical hyperbole. But
Okay, let's talk about it. In fact, let's just set aside the rhetorical hyperbole, however you say that, sorry, and just talk about it from the opinion standpoint. So it is certainly the defendant's position that, I mean, she's got multiple defenses, but one of them is that some of the stuff she said was just her opinion. I can think of an example probably. At one point, she says the plaintiff is a nasty bee, you know? Of course, she says the whole word, but there's no thing, in fact, of someone being nasty because nasty is an opinion based word in the abstract, you know? Depends on the context that it's used. And what I would think would be nasty generally, not in this context, my college age kids would think would be normal. So, I think that is opinion based, that word. Um, I don't know that that word itself, that's the phrase used by the defendant, could be found to be defamatory. Now, the facts that she relies upon to make that conclusion, and I think she, through some of the videos she put out, she discusses those facts. And to the extent that those facts are not true, then she probably can be found to defame the plaintiff in that regard. But given the defendant's position that much of what she said was simply opinion, I would have to tell the jury that things are just based on opinions. Statements made that are just opinions aren't actionable, right?
so the way that the law distinguishes between a fact and opinion is actually addressed in the very next charge, which is what we had concluded, which is, stated differently, an opinion can constitute actionable defamation if the opinion can reasonably be interpreted according to the context of the entire statement, in which the opinion appears to state or imply facts about the plaintiff that are capable of being proved false. So, whenever this discussion comes up in the decisions, the courts are very clear. Like, there's no exception for anything that might be labeled an opinion or might be labeled hyperbole. The pivotal question, in fact, court's decision even used that language, is what is already addressed in the charge that I just read to you. So, obviously the parties may have differences of opinion as to how the facts line up with that standard, but that is the standard. And so this other paragraph above from the jail decision is sort of like a subcategory within that opinion issue. Like, we don't believe that charge is necessary at all, but if we're going to include it, there are things that, we believe need to be corrected to make it.
Okay, so was there another charge which would imply or state that simple opinions are not actionable? You do agree that that's true, right? That simple
Well,
opinions are.
but simple opinion just.
No, answer my question. If I said to put it in the sports context, I'm sorry. Miss Matz, are you a Yankees or a Mets fan?
I am actually a Red Sox fan, Your Honor.
Okay, great, because I am too. I like the Red Sox. I'm a Red Sox and Braves fan, so you won't care. I only asked you because you're the only person from New York. Anyone is, well, are you a Yankees fan?
I'm a Red Sox fan.
Good, okay. So I'm not going to offend you either. Anybody else from New York here? What fan are you of? Mets or Yankees?
Yankees.
Okay. All right. So you're going to love this. I said the Mets suck, and certainly there's a lot that you can point to say that well, like this past season, they were first for 80% of the season. They didn't win. I mean, that's opinion, right? I mean, that's not actionable. So I couldn't be sued for that because it's my opinion based on their performance.
Right. But it doesn't state a fact that's capable of being proved false. That's the point. That's how we distinguish between an opinion and a fact.
Okay, how about this? I'm a Georgia fan. You know that. If I said Saban sucks, you could probably prove that that's not true because he's won 7 national championships. I might base it just on the fact that I don't like him with my teams most times. That's capable of being proven false, but yet it's opinion. That's not actionable. But if he if the well so go back and let's pull the example of this case. The defendant said that the plaintiff was a nasty bee. I mean, I don't know what you can prove that you can even prove that false, right? I mean, that's her opinion based on what she knows, based on maybe more than this, certainly, but based on the fact that the plaintiff has even testified that sometimes she doesn't wear, certain clothing. I mean, that's not.
Right. But we're not alleging that statement is defamatory.
I don't, I don't know that you're not. I mean, you've played the videos where she said that.
I think the instructions make clear, Your Honor, what we have alleged as defamatory
And that was what?
on page 6.
But it's related to that at the very least, because that was the whole discussion. Remember, is that I think that she may have caught some type of disease that her body might be irritated because of her, dress codes or dressing practices. I just don't think that her statement of what she believes and how she interprets, I'm sorry, when I say she, I'm referring to the defendant, how she interprets those facts, situations can be actionable. Now, statements that the plaintiff has some type of disease based on it, if untrue, could be actionable. Somebody proves it untrue. And there's certainly evidence here that it's not true, and it's not somehow privileged because it was without malice and was not reckless. But I do think there were some opinions in this case because there's a lot of that the defendant said, which, I sort of indirectly referred to it. I mean, that I thought that maybe her friends and her family in Panama City would be shocked by some of that stuff. But a lot of it is, just her giving her own view of the plaintiff, which isn't positive, but also not actionable necessarily. So I do think that there's opinion here that has to be separated by the jury. They have to decide these very points. What was opinion? And certainly it's their defense. Here's the thing. You don't interpret it as such, but the defendant does. They say it's opinion, and I don't get to side with you whether it is or it isn't opinion, because that's the jury's decision. And I can give you a good example in criminal law. Defendants sometimes have the worst theories of why they're not liable why they're not criminally responsible, but it would be error for me not to charge the jury on those defenses and let the jury decide if the facts, as they find them to be, support the defenses that the jury or that the defendants put forth, even if I think it's not likely that it would be successful. If there's any evidence, I have to charge it. And in this case, there's these statements that the defendant made and that y'all debate as to whether or not they're opinion or not. I've got to give the instruction, don't I? That lets the jury know that if you find it to be opinion, that it's not actionable. But if you find it to be fact-based, or as you say, the facts on which the opinion that the defendant relies in making the opinion are not simply true, and that the defendant was wrong to state them as facts, then maybe you can. So that's why this instruction is in there.
So, Your Honor, we're not disagreeing with the general principle that you just articulated. I think the issue is how we're communicating this to the jury. And what courts have made crystal clear is that whatever statement is labeled is not material to the question. So, if somebody simply says it's an opinion, that doesn't make it an opinion.
Sure. But if it is opinion, it is an opinion. If it is an opinion, it's not actionable.
Right. And the standard for that is whether the statement could reasonably be interpreted as stating or implying facts that are capable of being proved false. So,
Let's just use my example of she's a nasty bee.
and the defendants can say that that statement, they can make clear that these statements that they were making about them and their view are simply opinions about her in the sense that they don't communicate a fact about her that's capable of being proved false.
You know, go to the main paragraph that you were talking about, second sentence. If an opinion is based upon facts already disclosed in the communication, the expression of opinion applies nothing other than the defendant's subjective interpretation of the facts. So we go to the underwear situation, cab. And I won't go beyond that into I won't go into like the photographs that I'm sure y'all cannot agree to that demonstrate anything else. I'm talking about the herpes stuff. But if the jury thought that the nasty bee comments were based upon, say, the underwear situation, clothing choices or lack of clothing, then a person calling someone a name like nasty bee based on that, would that not be opinion?
Well, it's non-actionable in the sense that if they've stated facts that are not defamatory, and it's clear that the expression of an opinion is based off of those facts that are non-defamatory, then that's not actionable.
But I've got to tell the jury that, don't I? And that's what this instruction tells them is that very fact. If an opinion is based upon facts already disclosed in the communication, the jury would have to decide, does that statement, she's a nasty bee, apply to that allegation or some other allegation? The expression of opinion implies nothing other than a defendant's subjective interpretation of the facts.
Well, circling back to this specific charge, and I think our biggest issue with this, Your Honor, is that you actually read the jail decision.
I've got it on my phone right here.
Okay, so if you look at the language that this is a language from the court's decision, but if you look at the language they actually cite as support for the proposition that comes from the restatement.
I got to find it though, unfortunately, because I've got it on my phone and not on my computer. I don't have head notes. I'm there, but let me read it.
Brief pause.
Okay, so I read the part in the opinion. So
Right. So I think the issue that we have is that the language that we have here does not make clear, in our view, that this would not apply in situations when the communication relies on defamatory facts. So, like if you
wait, say that again now. Say it one more time.
Okay, so for example, in the second sentence where it says if an opinion is based upon facts. So the issue here is that it can still be defamation if it's relying on defamatory facts in the communication. It can still be defamatory if it's implying there are other defamatory facts that are not in the communication. It's only pure opinion if it's relying on truthful facts, and it doesn't imply that there are other facts that it's relying on to make that opinion.
Isn't that what I mean, so we're quoting, by the way, when these instructions are finalized, any citations to cases and stuff will be taken out. We just left those in there so you'll know where they're coming from. So the Georgia Television Company case, as you know, it's stating that restatement and the restatement, I think, is quoted accurately where it says in the last sentence, thus a defendant is only liable for a statement of opinion if the opinion implies the allegations of undisclosed defamatory facts as the basis for the opinion. That's in.
But that's, I'm sorry, Your Honor.
You don't think that's right? You don't think the restatement is.
It's not only if there are defamatory facts that are in the communication, our issue is that suggesting that if you
I'm sorry, defamatory facts in the communication?
in the communication. So this only refers to the last sentence only says only liable if it implies the allegation of undisclosed defamatory facts. The point is that you can't also include defamatory facts in the communication. So for example, if you just I can suggest some revisions, Your Honor, that I think are consistent with the case law.
So is your dispute with the word undisclosed then?
No, Your Honor. So the sentence, what we would suggest is a sentence that starts with if an opinion. We would suggest if an opinion is based upon facts, insert that are not defamatory and are already disclosed in the communication. The expression of the opinion implies nothing other than a defendant's subjective interpretation of the facts. And the next sentence, thus, a defendant is only liable for a statement of opinion if the opinion, insert, does not rely on defamatory facts or imply the allegation of undisclosed defamatory facts as the basis of the opinion. Your Honor, I think it's also consistent with the Malkovich Supreme Court decision that we cited in support of our charge, in which the Supreme Court says even if the speaker states the facts upon which he bases his opinion, if those facts are either incorrect or incomplete, or if his assessment of them is erroneous, the statement may still imply a false assertion of fact.
Okay, let me make sure I understand how far you're interpreting or the breadth of your interpretation. Are you saying that if the defendant gives her opinion about what someone else has said, that she can be and says, look, I think that she is whatever because of these facts stated by Stormy Reed Jones, that she could be held, she could be liable for that? I'm not talking about the opinion that she gives of the facts that Stormy Reed Jones states, that she could be liable for that if she doesn't have malice and isn't reckless in her relying on those facts. I mean, I don't think you can say yes to that because that, if she's not reckless and she's not, doesn't have malice, then she can't, by the very nature, because your client is a public figure, be legally liable, right?
Well, we can't recover from any statement if we haven't shown actual malice.
Right. But you're arguing that some sort of, because you're saying that she could be liable for defamation if she gives her opinion about facts that are out there or facts that she discloses that aren't true. And that's not true because if she doesn't have malice and she's not reckless in relying on those facts, she's not liable. And it could be that all of this is sort of caught up in some degree because we have a different standard for public personalities, public officials, under the New York Times standard. As a private individual, if someone says something about someone else, you don't have to show malice and recklessness if it's untrue. I guess if you go to the PTA meeting and you said that the lady next door had an affair, since that's one of the allegations here in the meeting, and I think that's horrible, I guess you could be liable for that, but in the context of a public official or a public person, that's not the right term. I'm not sure what the New York Times term is, but we'll all agree that it applies here. There's not going to be actionable unless you have malice or recklessness and relied on those facts. So it seems like the suggestions that you seek for me to put, I'm not saying this is all correct the way it is. I'm not saying this to really defend it necessarily, but I can't put something in there that negates one of the elements, right? I mean, it implies that malice and recklessness is still not a part of this.
Right. And that's, I don't believe that our suggestions would do that, or that, I mean, I guess to come at it from the other side.
Let me take this sentence by sentence, okay? So we'll start with this paragraph of a defendant who makes statements. You don't disagree with the first sentence, right? A defendant who makes statements of rhetorical hyperbole, that sentence is okay for you, right?
Other than the rhetorical hyperbole, which I don't,
Other than that, other than what?
other than the rhetorical hyperbole.
Okay, I'm not going to agree with you on that. It's not rhetorical hyperbole, then we don't have to worry about it. I think arguably some of it is. If you look at the definition of that term, I mean, it's using exaggerated language to make your point. It's essentially what I interpret it to be.
Just to be clear, Your Honor, that wasn't my point.
Okay, okay. So, other than that, though, but all right. And then your problem with the second sentence is that it seems to be limited to already disclosed in the communication, and that it's not broader. If the opinion is based upon facts already disclosed in the communication,
I think, just to try to succinctly summarize our issue, is that it refers to all the facts in the restatement that.
it doesn't. It doesn't. It says based upon facts already disclosed in the communication.
Right. And it doesn't distinguish between defamatory facts or truthful facts,
Mhm.
which is the issue that we find problematic. It's inconsistent with that, with what is said in the restatement. It's inconsistent with Malkovich, Your Honor.
But if it's okay, if they're not truthful facts and you don't know it to be truthful, and or you're not reckless and knowing that it's untruthful, then that can't be defamation in this context, right?
We're not trying to avoid the actual malice standard. I think the issue we have here.
But look, that's the case we have.
No, I understand that.
So the language needs to be tailored to this case. And in this case, just being untruthful is not enough, right? So you want me to add the word not truthful. Why can't why can't I just say facts? I mean, opinion is based upon facts.
Your Honor, we didn't propose this charge. We don't think it's necessary at all. And the issue is that the way that this reads is it's almost like a safe harbor. Like the jury could read this to say if she has cited facts in her communication and it doesn't imply the assertion of any other facts, whether those facts are true or not, then it can't constitute actionable defamation. And that is not the law.
That is the law.
The statement makes clear.
But it's modifying an opinion. It's not the facts. Your claim for defamation is twofold. One is that she states facts that aren't truthful. This instruction is not talking about facts, it's talking about opinions, and says that if opinions are based on facts, that the opinions aren't actionable, as opposed to, I mean, the facts are still actionable, right? If, for example, the defendant says and reveals that the plaintiff is a prostitute, that's not an opinion. That's a fact. That's an allegation of a fact. I mean, it's not necessarily true or untrue, in the abstract, but it's not an opinion. This instruction is all about opinions, right? And so when you argue your closing, you argue that there's malice because of the facts that she has stated. Is there anything in this opinion, I mean, in this instruction, that would say that someone who reveals alleged facts that are untruthful, they're somehow not liable for that? Doesn't it all come back to, in this instruction, whether it's an opinion or not?
I think the issue, Your Honor, is we believe there's a chance that the jury could read this instruction to mean that a statement that includes facts whether those facts are true or not, as part of the communication, that statement and that communication or that communication could not be actionable for defamation. I mean, if Your Honor, what you just said, if you feel like that's the simple interpretation of how a jury would interpret it, then I would just submit we should just make it clear.
We should make it clear what?
I mean, for example, if you want to say, it doesn't mean that if the same communication also discloses defamatory facts, that those defamatory facts are not actionable, or we could quote directly from Malkovich, the U.S. Supreme Court.
Well, the U.S. Supreme Court doesn't provide the context of defamation from Georgia, right?
It establishes the actual malice standard.
Yeah, but that's all. It doesn't. The state of Georgia decides what its elements generally are. The actual malice requirement under the New York Times case is just simply the federal court stating that you can't have a defamation claim against a public person because of the First Amendment unless you can show actual malice.
But the First Amendment is also encompassed within the distinction between statements of fact and statements of opinion. And if you look at the Georgia cases,
Yeah, but I don't think you look at the New York Times decision to say that it's really, I'm not going to argue with you about that. I mean, states have the rights to make their own laws subject only to their consistency with the United States Constitution. And I think that case simply dealt with the First Amendment stating that you can say anything about public official you want to as long as you don't have malice or reckless disregard for the truth. So states are still free to add additional elements like, for example, the states can say and sue someone for defamation if it has said to be 5 times. States could say that, it's got to have a 5-time limit threshold or they can limit the amount of damages. I mean, there's a lot of things that states can do because it's their claim. It's not a federal common law claim. We're not in federal court because of the substantive federal law. We're in federal court because of diversity and applying state law in that regard.
I just would.
So I'll have to think about it. I just can't take up any more time right now, but I will talk. I will talk. Mr. Roberts, Mr. Roberts and I, Andrew and I, we'll get together and talk about it. Let me though ask the defendant for any supplement that you want to make to this whole discussion.
Thank you, Your Honor. We object to the plaintiff's proposed changes. We believe that the court's instruction is consistent with Georgia law. We cite this instruction in defendant's request to charge number 23. We absolutely object to editing or adding any additional language. This is the law in Georgia. It's cited in many different cases that I've read that are still good law. And we would request that the court keep it as is, because the paragraph after this paragraph that the plaintiff has taken issue with does in fact state that if it is, if the opinion is made on facts that could be proven false, then that is defamation. So their concern is addressed in the court's charge.
All right. We're gonna move on right now, and I'll let you know before you argue exactly how I'm going to finalize this. Anything else from the plaintiff?
Yes, Your Honor, on page 8, discharge on the per se categories.
Sorry, the top of the page, bottom of the page?
So the first full paragraph, if you find.
All right.
So, Your Honor, I mean, this is an issue of law, and it's been our position that, there's not really a reasonable dispute about the categories that we're talking about here, but I understand Your Honor's potential concerns about that. So I would just say that if we're going to put these categories to the jury and we say crime punishable by law, that we have to actually specifically define. If we're going to include this, we have to specifically define the crimes that we have that are at issue in the defamatory allegations.
Can't you argue that? We've already mentioned the adultery thing.
Sure, we can read the criminal tort.
So you're saying the jury won't know that adultery is illegal?
I don't know if they will or they won't.
Is that your point?
I don't know if they will or will not know if that's a crime in Georgia. If Your Honor would prefer, we just read the statute to the jury. We can do that. But that was only our suggestion.
So your point is that, okay, we mentioned adultery over on previous pages about,
Adultery and prostitution. It's just the question becomes, will a juror know that those two things are crimes in Georgia?
I flipped over several pages, so I lost where you were.
Page 8, Your Honor.
What page?
Page 8, it asks the jury to determine whether the statement is a crime punishable by law. I don't know if we can assume the jury would know that.
All right. So what if I added such as adultery,
And prostitution.
crime punishable and crime punishable and prosecution?
Prostitution. Those are the two.
Okay. Oh, okay. I see. All right. Does the defendant have any objection to that?
No, Your Honor.
Okay, what I'm going to do is I'm going to put it in parentheses, but I'll read it, such as adultery or prostitution. Okay.
Okay, the very last sentence is just a small semantic suggestion on the bottom of page 8 where the sentence ends order to recover. We just propose adding for that statement just to make clear that the limitation only applies to whatever statement they found does not meet one of those categories.
I don't understand. I mean, if you find that one of the defendants, I'm reading it now, quote, if you find that one of the defendant's statements is defamatory, does not fit into the categories just listed, the plaintiff must prove by a preponderance of the evidence that she suffered damages actually flowing from the defamation in order to recover.
And I'm not proposing adding for that statement just to make clear of that.
All right. Any objection to that?
No.
Okay, that's added then. Anything else?
I think just one more, Your Honor, on the attorney's fee charge, which was on page 16.
Can I ask y'all, did we agree in pretrial conference that the amount of the attorney fees would be left to the second phase of the trial, or did y'all just assume that?
It was jointly requested in.
Okay, because I just didn't remember discussing it. I don't know if we discussed it or not.
I don't think there was a specific discussion about it, Your Honor.
There was?
I don't believe there was. We included in.
Okay, well, the last case I had, we did do that. We did it that way, but it's not normal that it's done that way. It's normally done as part of the first phase of trial, but it doesn't. I mean, it makes sense to do it in the second phase, given that it's punitive damages phase. So what's your point about the...
Just, the language that says when the plaintiff has specially pleaded and has made prayer, therefore, obviously that's from the statute. I guess our only issue is it just suggests an additional element that's not really in dispute that, the jury might feel like they have to resolve.
You're just asking that I strike the first where the plaintiff
Yes,
has specially pleaded and has made a prayer, therefore, and so it would say, but where the plaintiff has acted in bad faith.
exactly.
Okay, any objection to that?
I'm sorry, I'm not. And what are we trying to strike?
So the first sentence says in semicolon, but strike but all the way until on to the next line. So strike but where the plaintiff has specifically pleaded and has made a prayer, therefore, and strike all that. And so it would say, but where the plaintiff has acted in bad faith is what it would read.
Where the defendant has acted?
I'm sorry.
You mean where the defendant has acted?
Yeah.
You mean, yeah, that's fine.
All right, I'll do that.
That's all I have, Your Honor.
Okay, all right. Thank you. Ms. Ismailova, anything you want to talk about related to the instructions that we haven't already talked about?
Yes, Your Honor. Just briefly, when we were on page 8 in that same paragraph, it says or was otherwise injuries to the plaintiff on its face without aid of, and it says intrinsic proof, but I believe that should be extrinsic, extrinsic,
Extrinsic. Okay, yeah, that makes
extrinsic.
sense. It makes sense.
But I'm not sure.
It makes sense that it's extrinsic.
I just wanted to point that out to the court.
Well, great thing about the Georgia code system is that it is the only system that uses 3 sets of numbers divided by hyphens, and so y'all haven't ever realized that. Well, whenever you put it like Georgia code section, it's going to come up, and no other states will come up because no other states uses that system. I'm sure that our codifiers were not that smart to know that that's the way it would impact the internet years later. Okay, let's see. I can't find it in this code section, so I'm not looking at the case, but it does make sense that this is extrinsic, doesn't it?
It does. I don't know for sure, but I just wanted to point that out to the court.
Okay. We'll take a look at that and see if we can figure that out, okay?
Thank you, Your Honor. And I just have 2 points to bring up. With regard to defense request to charge number 20, the actual malice definition, and in the court's charge, this is on page 6.
All right.
We would request that the language that actual malice is not merely spite or ill will or even outright hatred be included into the court's charge, because I do believe that there is at least some evidence that, my client may not like the plaintiff, but I don't want the jury to misconstrue her dislike for the plaintiff to be sufficient to prove actual malice. And then,
hold on a second. Hold on a second. I'm reading through what's in here already.
I apologize.
All right. What's the plaintiff's response to that?
Your Honor, if the concern is that they are afraid that the jury would confuse actual malice with ill will, we don't have an objection to clarifying that those two things are different. I think our concern with what the language they had proposed is that it suggests that we have to prove ill will in addition to the standard for actual malice, because it says not merely.
So you don't like the word merely?
Yeah, we don't like the fact that it suggests we have to prove both. We don't object or disagree with the notion that those two things are different.
And I'm fine with taking out the word merely, Your Honor.
Well, we have to use the word constitutional, don't we?
I was only quoting from the case, so I mean,
quoting from the case, from the
Contrell versus Smith.
Well, yeah, trying to interpret what the Supreme Court said was constitutionally required, but I don't think we need to tell the jury that it's constitutional.
That's fine.
Hold on a second.
Brief pause.
So what I'm going to do is I'm going to add this on page 6 of the proposed instructions, first, second, and third. And then right where it starts to define actual malice, I'm going to say actual malice is not spite or ill will or even outright hatred. Rather, actual malice is a defendant's actual knowledge that a statement is false or a defendant's reckless disregard as to the statement's truth or falsity.
Thank you.
Okay, is plaintiff okay with that?
That's fine, Your Honor.
Okay, what else, ma'am?
And then from the same charge at from the defendant's proposed charge, the third paragraph where I wrote it is not sufficient to measure reckless disregard by what a reasonably prudent man would have done under similar circumstances. I would like that language added because I believe even in the opening, the plaintiff stated that, some of the things that my client was doing is not, and no reasonable person would have done this. They said something along those lines. And I would like that language added in because I do not want the jury to be confused about that standard is that it's not a reasonable person standard. It is they have to look at what the defendant actually did.
All right, what's the plaintiff's response to that?
Your Honor, I think that the language just is confusing as it relates to the rest of the actual malice charge, and it's unnecessary in light of what the court already has.
Explain to me how it's confusing. What would it mix up?
So the language that they're asking to include is what a reasonable, prudent man would have done under similar circumstances, not whether a reasonably prudent man would have conducted further investigation. I think the issue with actual malice and reckless disregard standard is that we're looking at sort of subjective things related to the defendant. And so
Which is that? I guess the way I interpret what she's asking for is she wants to make the jury understand that it's not an objective standard.
That's correct.
Okay. It really is kind of weird that it's not, honestly, because I mean, this may be one of the, I mean, reckless disregard normally is an objective standard.
And that's why I would like that in so that they know and the difference.
Take, for example, the Georgia crime of theft by receiving. Theft by receiving is if you receive something that you know is stolen, or you reasonably should have known that it was stolen, and that's not, I mean, that's a reasonable man standard or woman standard.
I think all of the criminal ones are reasonable because, like, even the drug, like when you're carrying something, you say it's not my bag. Well, if you thought that it was, you should have known there might have been drugs in it. Also, a reasonable person standard.
There's something else in there, and I asked this to the plaintiff. Um, is there something else in here that would make it clear to the jury that it's a subjective standard and not an objective standard?
I guess my concern, Your Honor, is just that there's some tension between that statement and what I think is a clear statement of the law in the following paragraph.
I mean, you agree, though? It is a subjective standard, right?
Subjective in the sense that the facts that are supporting the reckless disregard have to be related to the defendants. They can't just be so just using the example we have here, like if the source of a statement there's evidence that the defendant was aware that this person was unreliable, then that's evidence of actual malice. So I guess the problem I have with the language is just that it could be read to suggest something different, and I don't.
Okay, okay. So let's take Star Marie as an example, since that's probably the biggest one in this case. There's certainly some evidence here that might not be reliable, and the defendant would admit that as to some things. I don't specifically remember every situation in the room with the third gentleman was there. Might be one of the things that the defendant pointed to as being something that she didn't really trust. That got published anyway originally, and so, but Star Marie said it happened. And there was, some general reasons for the defendant not to have trusted Star Marie, her criminal convictions, without delving more into what they were about. The fact that she lied about some things, she admitted that she lied about some stuff, and even in the interview. I don't remember what it was, but she discussed why she did. And so, how could a jury determine whether or not it was proper for the defendant to rely on anything that Miss Jones said? Now, an objective standard would be you don't rely on anything that she says until you probably perhaps have a second corroborating source, which is why, traditional news media use that as standard, particularly when you're alerted to the facts that her background was a little sketchy. But if it's not, if this statement of the law is right, that it's not sufficient measure of reckless disregard by what a reasonable, prudent person would have done or under similar circumstances, like get a second source, then I guess I don't know how the jury does that. I mean, honestly, this whole parsing of subjectivity and objectivity seems real difficult for anyone. I guess this comes out of New York Times case. I'm not sure. I mean, no, this is not the case that's quoted. It's a Georgia case, but because the New York Times set up the reckless standard too, but I don't know. So help me. How would we tell the jury that it's not what anyone else would have done with the knowledge that which Miss Keeby had and distinguish that from your argument that she should have done more based on what she knew? I mean, I don't guess I understand it, quite honestly.
Your Honor, I think that there's some tension there because I think that the quote that is coming from the Cottrell decision is sort of one of these broad statements. It's not really being applied to these specific facts. And then the following paragraph, which is, I think, undoubtedly a fair characterization of the law under the St. Amant decision, is addressing the actual situation we have that we're addressing. So, Your Honor, is, I guess, recognizing the tension, which is our concern, is that the statement that they're pulling from a decision is not really addressing a situation.
Okay. So I'm just trying to think. I like to deal in analogies, so I'm thinking up one we would all know. If a certain mayor of New York were to come to me and tell me that there was voting irregularities that might be perceived by me differently than if someone from the FBI or the GBI were to come and tell me that there were voting irregularities. I would think if I relied on what the mayor told me and I went out and I said certain things, given everything that we know about the body of statements that he made, then maybe that might fit the definition where in the next paragraphs you referred to where it says a defendant cannot profess good faith when the statements are so inherently improbable that only a reckless person would have put them into circulation. If the FBI came to me and said something that might be totally different, gosh, that seems still to be an objective standard, though. I don't know where the subjective, it's an objective statement based on what I know about speakers. You know, what's been publicly disclosed about the speakers? I mean, to the extent this case turns on this issue, what's going to happen is the jury is going to come back and they're going to ask me, well, how do they do this? How do they decide, And I don't really know what to tell them if it's not a reasonable man. And we know that it's not. That I guess based on Cottrell decision, since Georgia law gets to control that part of it, in what context did Cottrell use that statement?
Your Honor, I don't remember because I wrote this a while ago, but I can go grab that opinion.
All right. So I'm just going to make a note. I'm just going to make a note that Andrew and I need to talk about this a little bit more, and I'll let you know what I decide about that. So okay, anything else from the defendant?
No, I think that was it.
Okay, all right. So we'll take a 10-minute recess. We'll come back. I guess Ms. Keeby will still be on the stand.
Your Honor, I'm sorry, not in regards to this, but I do have something else to bring up. I thought you were talking about the jury charges.
Okay.
We do have a motion for Your Honor based on the cross-examination that already occurred yesterday. Ms. Matz, seemed to suggest that my client was lying about all the other tweets that she had seen from dating back from 2015 to before the Star Marie Jones interview that was referring to, talking about plaintiff having herpes and even tagging her in some of those tweets. We do have copies of those tweets, and we would ask to be able to present that on redirect, given that the fact that Ms. Matz suggested that my client was basically lying about the existence of those tweets.
Are those tweets from
random users, just like my client testified, from Twitter dating back to 2015, between 2015 and 2018, before the Star Marie Jones interview, posting about the fact that, plaintiff and herpes, and even tagging the plaintiff in some of those tweets. And specifically yesterday when Ms. Matz was questioning my client, she said, well, where are those tweets? Are we just supposed to trust your word that they exist? And so I believe that because of the way that because of the question that were said to my client, I believe that we should be able to now present into evidence those tweets so that the jury does not think that my client was lying about that.
And these dealt with the herpes issue?
Your Honor, I have copies of them if you would like.
Well, just tell me. They deal with the herpes?
Correct. Yes, Your Honor.
And your statement is that your client not only testified about it yesterday, I suppose, but that these were things that she relied on when she made the statements?
Correct. And that's...
Have I ever ruled these out?
So
Are they on your witness list?
they were not on our witness list initially because I did not anticipate the plaintiff ever getting up and saying that my client was the first person to ever say this about her, because that's just not true. So I didn't think that it would be necessary. But the way that Ms. Metz made it seem yesterday was that my client was making that up. And so I believe that at this point, we would be allowed to present that in her redirect or rebuttal.
Okay, in her rebuttal.
No rebuttal, but in her redirect, Your Honor.
Okay, anything else you want to talk about? Is that it?
That was it.
All right, Ms. Matz.
Yeah, hold on, y'all.
All right, guys. You guys are doing awesome. Awesome. Guys, I just want to tell you that transcripts don't lie. They reflect exactly what happened in court. Just want to tell you. You hear all of this that's happening, and you see, I don't know, these people, I tell you. But how's everyone doing this evening, everyone?
I'm doing well.
Awesome.
Oh, I'm doing good. I thought you were
That's-
talking to your chat.
No, I'm talking chat and you guys.
I am so glad that we're doing this so we can actually see the full picture of it.
Yeah. Oh, guys, I started reading the 2008 transcript for Robert Kelly. Lord have mercy. Robert's coming home.
Well, we need you to quit teasing us with the 2008 transcripts.
He's coming home. I'm telling you,
Into
Mel.
existence.
Mel,
That's
he's
right.
coming home. Y'all, if you read some of the stuff in that transcript, that's why public didn't know. This stuff that's in there, the public, even the jury didn't know.
Mm.
Mm-mm-mm.
I know there's a lot of stuff I didn't understand until I started. This Cardi B case brought me to your channel, and then I started listening to everything, to what was going on with Mr. Kelly.
Mm, 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 mm. Man, I tell you guys, when I tell you, now I know why he was found not guilty in 2008, because he was not guilty. It is in the transcript.
Facts.
Facts, right, Miss Tasha K?
Witness facts.
What page are we on?
Look, okay, I won't say no more.
64.
Okay, let me.
She said 1 second. She's almost there. Black Beauty says, "Say no more." I'm just saying. I know why he was not found not guilty, because he's not guilty, and that's all I'm gonna say. Teaser alert. Woo. Mm.
All right, I'm at six. We're at 64. What? At the top of the.
Line 2, Miss Matz.
Okay.
Oh, tomorrow I will not be reading this Cardi B. I'm gonna be in my own backspace. We going over the R. Kelly 2008 trial. I'm not doing it on my channel. I'm just doing it in a backspace with those, so you guys will know what happened. My apologies for those who, but we have to do it privately. Sorry.
That's right.
Yeah, so. Ms. Ja. No, they didn't, because those transcripts cost so much money. A lot of people, one of the things they were saying that they weren't gonna get it because it cost so much.
I'm joking around with Toria. She said, "Love you, TK," and I'm like, "Oh, it's not every day we gonna hear that over here." Not every day you're gonna hear that, Tasha. Come relish in
Tanya,
it.
you still support Tasha K? Oh my God, Coco, what is wrong with you?
I think she's talking about me. She got to be talking about me.
Oh, Coco, I'm gonna beat Coco's tail. I'm telling you, I've been me and Coco been fighting for a while now. Coco, I'm gonna beat your tail. I'm gonna beat your tail.
Still
Okay, y'all.
support her. Just know that no lies were told about her. Support her. No lies were told about her. She did defame Cardi B. She was Malice. She was doing some reckless stuff. Support her, but support her knowing that
She lied.
she lied. And you're okay with that because for entertainment value, you like that mess. It's all good.
Okay, I'm sorry. I had to take
Hey,
that call.
MC8. Thank you. All right, guys, we back. Roll 'em.
All right. So, first of all, I like to know if these were ever produced in discovery. And the second thing is, I did not bring this up. Mr. Sabak asked her what the basis was for her statements. This is part of their main defense. They had an obligation, whatever evidence they wanted to produce to the jury, to show that she has a reasonable basis to rely on whatever she's saying she relied on. That's the main piece of their defense. They absolutely had an obligation to not only produce that in discovery, but have it on their pretrial order list. And if they wanted to put it in on their direct case. It's perfectly within my rights to cross examine their client about statements she's making about evidence that she's talking about that she saw that's not being produced to the jury.
Have you seen what it is she wants to put in now?
I don't know. This is the first time hearing it.
So, Ms. Ismailova, has this ever been produced by the defendant to the plaintiff?
No, Your Honor, because again, I did not believe that the plaintiff was going to lie about that my client was the first person to ever say anything about her having herpes on the stand.
But that's not the standard about whether you produce it in discovery. The standard, if you produce it in discovery, is when there's a question. Was there a request to produce that would have included evidence that the defendant relied on when she said the plaintiff had herpes? I'm going to guess there's probably such a question.
There was also requests for any evidence that they intended to introduce at trial or rely upon in this case.
Oh, you can't ask that.
I didn't intend to.
Wait. You can't ask somebody to produce what they're going to introduce at trial, right? I mean, that's work product.
I'm sorry. You can ask them to produce anything that they're intending to rely upon in their defense of the case or that supports any of their defenses.
You can ask it generally, but not like trial, because that's attorney decisions and that's work product, I think. But I'm going to guess that there was a request that would have covered this. The plaintiff, the defendant may not have thought they needed to produce it because it would not be necessary, since it was well known, allegedly, that the plaintiff had this condition or that other people had said that she did. But that doesn't excuse not producing it, right? I mean, you still have to produce it. Wait a minute.
Sorry.
I agree with you, with Your Honor.
So just follow my logic here. So then when Miss Matz gets up and she asks her questions about her, your client, or questions about what the proof is, having not had any of those documents given to her, it would seem natural that the plaintiff would want to point out that she's just saying this and there's nothing to support it. And then now you're telling me there is something to support it, and that kind of affects the plaintiff's case. They may not have gone down the road of asking those kinds of questions had you produced it. I mean, you just can't simply say it's out in the stratosphere. Everybody knew that. I mean, particularly when it was requested in discovery.
I don't recall if it was specifically requested in the question that, Your Honor. How Your Honor has formed the question, I do not remember. I'm not going to say it wasn't.
Well, let's wait a minute. Let's wait. Miss Mance, can you find a request to produce that?
I'm looking, but I have two more points while I'm looking, Your Honor. First of all, no one has said that this was the first time. My client actually admitted on the stand that, excuse me, Miss Azalea Banks had made some prior allegation. And the other thing is, I frankly think that this should have been a category of documents that's subject to the automatic disclosures under Rule 26. Anything that you're intending on to support your claims or defenses has to be a category, and it has to either be produced with your initial disclosures or later in the case.
That is true, right?
Yes.
I mean, Rule 26 doesn't apply under Georgia procedure, but it applies in federal court. And
Yes.
that's a pretty big point because, in fact, as it relates to herpes, it's about as big as they get, because she says there were all these statements of people saying she had herpes. And so when I heard Star Marie Jones say that she had herpes, and particularly when I saw the photographs that showed she might have had some cold sores, and knowing that that is an element of herpes, that kind of provides a fairly tight defense for the defendants. But it starts with all of this other stuff having been out there. So I guess my ruling is this: if you didn't produce it in discovery, it can't be used, because at this point in time, the plaintiff has gone down a road to ask questions and built their case on the assumption that there was nothing. And it would be unfair for you to use that now when you didn't disclose it to them, when the plaintiff may not have asked the questions the way they did. It would create an impression to the jury that counsel for the plaintiff was being misleading, when, if the information was not disclosed, the documents were not produced, then the questions would not have been posed the way they were. So I'm not going to allow you to use that. Anything else? That's why you've got to disclose everything. You're supposed to disclose everything. Anything else?
None. No, thank you.
All right. So we'll tell the jury, we'll call them in at 11. We'll take a break until 11, and we'll go until 12:30, and then we'll take a lunch break. All right?
All rise. Court is in recess until 11 a.m. Brief recess.
All right. Thank you. Okay. As soon as the jury gets in, if you'll come on up.
All rise, whereupon the jurors enter the courtroom. Please be seated and come to order.
All right. You can proceed. Thank you.
Thank you, Your Honor. Good morning. Tasha.
Sorry, I was muted.
Okay.
Good morning, Miss Matz.
So yesterday, when we left off, we were talking about the email that you testified came, you believe testified came from my client's business manager. Do you recall that?
Yeah. Could you bring it back up on the screen for me, please?
Yeah, we'll do that in 1 second.
Okay.
And before we do that, you had also testified that the Tasha K business at gmail.com is one of your business email addresses, correct?
I believe so. Yes.
Okay, that was one of the addresses we saw on the advertising portion of the Star Marie Jones video where you were soliciting advertisements, correct?
Yes, ma'am.
I'm sorry, I didn't hear the answer.
Yes, ma'am.
Thank you. I appreciate that. All right. Do you know who my client's business managers are?
I'm sorry. Right now?
No. At the time we were talking about this email, September the 19th of 2018.
I believe the same lawyers that her husband is suing were doing business for her because she was in a lawsuit with the current manager at the time.
your testimony, okay, so your testimony is that you believe the business managers that sent you the email were also my client's lawyers at the time?
I believe, I don't think they were her lawyers. I believe they were doing business for her, like just kind of looking at contracts.
Okay, and you have personal knowledge of this?
No, that's just my idea of how the media was kind of printing things at the time because she was in a lawsuit with her like prior management firm. So she didn't actually have like a dedicated team at the time, is what I read.
Okay, so when you said you thought that one of the reasons why you didn't think the cease and desist letter was real is because it came from business managers, you actually understood that the people you thought were business managers were also a law firm. Is that what you're saying now?
No, ma'am.
So you're saying the people who you thought were business managers were not a law firm?
No, ma'am.
Well, which is it? You just answered no to both questions. Do you think that they were also a law firm or not?
No, ma'am. They were just doing business on her behalf.
I'm asking if you understood whether or not they were a law firm, not whether they were acting as her lawyers, ma'am.
No, ma'am.
No, ma'am, you didn't understand they were a law firm at all?
No, ma'am. That is correct. No, ma'am.
Thank you.
Okay.
All right. If we can please pull up P514. And Your Honor, just for the record, this is a duplicate of what we were looking at yesterday. There was just a duplicate issue on that exhibit list. And if you'd like me to show both, I can.
So just to be clear, the duplicate document has already been admitted.
No, this is the duplicate document is the one we were talking about yesterday.
So 514 has not been tendered either, has it?
No, it's not in yet. We were talking about 515. 514 and 515 are the same document.
Okay.
I just wanted to make that clear. All right. So, ma'am, do you see this document?
Yes, ma'am. I see it.
And you see at the top of the document, it says from Tasha K. Tasha K business at gmail.com. Do you see that?
That is correct.
And that is the email address that we were just talking about that is associated with your business, correct?
That is correct.
Okay, Your Honor, I'd offer this into evidence.
Any objection? Any objection?
No objection.
No objection, it's admitted.
Whereupon plaintiff's exhibit 514 was marked for the purpose of identification and admitted into evidence.
Okay, if we could go down to the bottom or kind of split, I like to, there's two emails on this chain. Can we straddle all the pages, Tom? I think it should be a continuous scroll. Just show it in the middle, please. Perfect. Thank you. All right. So looking towards the cutoff of the first page, right before it says confidential Cardi 313, you see it says on Wednesday, September 19th, 2018 at 11:19 p.m. Do you see that?
Yes, ma'am. At the bottom.
Yes, at the bottom.
That is correct. Yes, ma'am.
So I'm talking about the Wednesday, September 19th email that's from Jamie Barada. Do you see that?
That is correct.
Okay. And that email addresses is jbarada at davisshaparo.com.
That is correct.
And below that, where the message starts, it says, please see the attached time sensitive cease and desist letter on behalf of Damian Granderson. You see that?
Yes, ma'am.
And then it says, this letter should be directed as soon as possible to Tasha K or to the appropriate person who makes decisions for Tasha K concerning legal matters. Do you see that?
Yes, that is correct.
And then at the bottom, it has her signature block. You see that also?
Yes, that is correct.
It says Jamie M. Barada and then slash Davis, Shapiro, Lewitt, Grable, Levin, Granderson, and Blake LLP. You see that?
Yes, ma'am.
Is this the email with the cease and desist letter that you said you showed your lawyer in Washington, D.C.?
Which cease and desist is attached?
I can bring up the cease and desist again.
Okay.
There wasn't more than one cease and desist that you got on September the 19th, correct?
Not that I believe so. No, ma'am.
Okay. So, Tom, do you want to bring up the video that we were looking at? It was D11, and I believe the time code was around 11:15. Real quick, just to refresh, Miss Kiwi, right there. Maybe so it's a little clearer if you could just move it forward a couple of seconds. Great. That's good. Do you recall looking at that yesterday?
Yes, ma'am.
Okay. And this was the do you need us to replay you the clip where you said I sent this to my lawyer in DC who looked at it and determined it was a fake cease and desist letter?
You said what was the question again? I'm sorry. What was the question again?
I said, "Do you need me to replay you the clip or do you recall saying that?"
Oh, no, I recall saying that.
Okay. And this was the cease and desist letter that you were talking about?
Yes, at that time, it's on the screen.
Okay. And so the email that we were just looking at, plaintiff 514, was the email that came with this, correct?
I can't say because it's blacked out. Why is it blacked out?
You telling me you think you got more than one cease and desist letter?
That's not what I'm saying. I can't agree to something and you have an email up there.
All right, hold on. So I'm sure there's a copy of an unredacted version of the letter, right? Y'all have that with you?
Sure. Well, we could look at, why don't we look at plaintiffs, excuse me, why don't we look at plaintiffs 863? Have you ever seen this before?
Yes, I believe this was forwarded from my TK business email to my husband, to me. So, yes.
Well, hold on. Let's just talk about the document. It's printed from Tasha K Business at gmail.com. Do you see that in the top right hand corner?
Yes, ma'am.
Okay, and at the bottom right hand corner, it says Kibi 552. You see that?
Yes, I see that.
Okay, and this was a document you produced in discovery, correct?
I produced?
Defendants produced in discovery.
Okay. If my attorneys gave it to you, then yes.
Okay, Your Honor, I'd offer this into evidence.
Any objection?
No, sir.
So I'm sorry. It was what's the number again?
I'm sorry, it's 863, Your Honor.
863 is admitted.
Whereupon Plaintiff's Exhibit 863 was marked for the purpose of identification and admitted into evidence.
Okay, so this was the email that the defendants actually received, correct?
Yes, ma'am.
Okay, so this is what you showed with the attachment. You see halfway down the page there, this is what you showed to your attorney in DC, correct?
It wasn't my attorney, it was my attorney friend, but yes.
All right, okay. And did you Google Jamie Barada?
Did I Google Jamie Barada?
Did you Google her to find out who she was?
No, because she's all over the news. You don't need to Google her.
She's all over the news?
In the lawsuit that she was with plaintiff's husband, this law firm.
You're saying that that was pending in, you're sure that that was pending in 2018?
I'm just saying that's how I know.
No, no, no. I'm asking you what you understood at this time, ma'am.
Oh, at this time, no. She was representing them doing business contracts and such.
Okay, and I'm asking if you Googled her to find out whether or not it was a law firm.
No, I didn't Google her because I knew who she was. She's in the news. No, I did not Google her.
At the time, you're saying she was in the news because you just told me that that came later.
Yes, that particular portion came later.
I'm asking you about your knowledge at the time you received this letter. Okay? Can we agree to talk about that for a minute?
Yes, I'm talking about that with you.
I'm asking you if you Googled her to find out whether or not she was an attorney.
I didn't need to Google her because she was representing the plaintiff's husband. She was in the news. I didn't need to Google her.
So you knew she was an attorney?
I didn't know she was an attorney. I knew she was doing business for her husband.
Okay, so you knew she was doing business and you didn't Google her.
Yes, that's correct.
All right. And did you Google the name of the business Davis Shapiro? I'm not going to read the whole thing. Did you Google that?
No, ma'am. No, ma'am.
So let me ask both of you, if you would, to allow the other person to finish. Oftentimes, Ms. Kibi, you start answering before she's finished with her question. And sometimes you start your next question when she's answering or attempting to answer some question that you've asked. So if y'all both just wait until the other person is done, that way the court reporter can have everything in sequence in the transcript. Otherwise, it's words on top of words.
Yes, sir.
All right. Thank you.
Thank you, Your Honor. I'm sorry, Wynette. Okay. All right. So you felt like you knew who she was. You didn't need to Google her.
That is correct.
All right. And who's your friend in DC that you said is the attorney that you sent this to?
I would rather leave her out of this because she's not a part of this case.
I'd like an answer to my question.
Answer the question, please. You need to answer the question.
But she's not part of this case.
Answer the question that was asked of you.
Can I Google her name? Because I was friends with her at the time.
Answer the question.
I do not remember her name. I can Google it in my email.
Okay.
You can Google it.
Yes, if I get my phone, yes, I can get her name.
If you'll bring her phone.
I don't have my phone with me. It's in my car. It's in a car.
Okay. Bring her a phone. Bring her something with internet capabilities so she can Google the name.
Can my husband sign into my email?
Sure.
TashaKibi@gmail.com. Thank you. Cheek, Google sign into unwindwithTashaK@gmail.com as well, because that's when I was doing the corresponding at the time.
Your Honor,
Yes.
the Gmail requires two-step verification. So if you know what that means, it requires Mr. Kibi to have his actual phone, which is downstairs. May he be excused in the meantime to go retrieve it?
Sure. I mean, he's not required to be here.
Okay.
And two-step, that means my phone as well. So he has to sign in to both phones to get into the email.
And he's not going to be able to bring his phone in.
He'll forward it to me or screenshot it.
Well, I don't think he knows what he's looking for, so I've got to look for it.
Tell you what we'll do. Is that lunchtime? We'll come back to this issue after lunch so you can find everything during lunch.
Yes, sir.
But I'm going to guess you can't bring your phone in, so you're going to have to go out and find it and then maybe figure out.
I'll screenshot everything to the plaintiff.
I'll take care of it.
Okay.
Okay. Do you know whether or not your attorney friend looked up the person sending this or the firm name to see if they were lawyers?
No.
Okay. Did you ask her if she did?
No, ma'am.
Excuse me. All right. So without either of you looking at this, she told you to wipe your ass with it and you were fine with that conclusion?
Well, I was. That was inflammatory. She just basically said ignore it. So I said wipe my ass with it.
No, you said, I talked to an attorney and they told you to wipe your ass with it.
Yes, meaning,
Correct. You said that yesterday in the video, correct?
but that's hypothetically speaking.
Ma'am, please answer my question.
Yes, that's what I said in the video.
Hold on, hold on, hold on, hold on. All right. So if counsel doesn't like the answer you're getting, just look at me and object for responsiveness to the answer. Then when I start talking, the court reporter will make what I say primary, I hope. I'm not sure, but that's the way it should work, I think. So otherwise, let her finish what she's saying and then object, okay?
Thank you.
Sure, Your Honor. So you said in the video yesterday that after looking at this, your attorney friend told you to wipe your ass with it, correct?
Correct.
All right. And you felt like that determination was good enough for you to go online and tell all your followers that your lawyer had determined that it was fake, correct?
Yes, ma'am.
Let
Let
me
me ask let me ask you a question. So as you understood it, what did it mean to say that the letter was fake?
Okay. Can we bring the letter up and I can describe it? There were certain elements of the letter because
I
I've
just want
gotten.
I just want to know what you interpreted that to mean. That there wasn't a real letter, or it wasn't really from the plaintiff, or wasn't from a lawyer, or what?
It wasn't, I guess, because my name, my address wasn't on it. It wasn't addressed to me. It was addressed to gentle persons. It wasn't signed. So basically, don't take it serious. Now, the second cease and desist, yes. But the first one, it was just kind of drafted in a hurry to just get over to me to take the video down. So that's how I took it.
But it did have your business email address on it, right?
Whose business email address?
Kiwi Studios business email address, correct? On tashakbusiness@gmail.com.
Can you repeat the question? I'm sorry.
The letter that we were looking at did have your business email address, tashakbusiness@gmail.com, correct?
That is correct. Yes, ma'am.
Thank you. So, despite going online and telling your viewers that it was fake, you responded, correct?
I'm sorry. Could you repeat that question?
I said, despite going online and telling all your viewers it was fake, you responded, correct?
I responded to what?
The email dated September the 19th, 2018 at 11:18 p.m. that we're looking at the top.
Yes. I believe my husband responded to this, if I'm not mistaken.
Your testimony is that he responded to it?
I believe so.
All right.
His name is at the bottom as well.
All right. I'd like to read a portion of his deposition testimony into the record. And I'd like to pull up plaintiff's 314.
Okay.
I'm going to page 90, line 4 through 91, line 11. No, that's not the right exhibit. I'm sorry. Did I say, I'm sorry, P514? I'm sorry. I think I said the Bates number. Too many numbers. All right. If you can just show the middle view. Okay. So this is another copy of what we were just looking at, part of it, right?
I believe so. Yes, ma'am.
Okay, when your husband was deposed in this case, you understand that he was testifying under penalties of perjury, just like you were, correct?
Yes, ma'am.
Okay, and beginning on page 90, line 4,
Of his deposition?
yeah, I'm just going to read it into the record.
Oh, okay.
It said, all right, I'm going to show you what I've marked for production as pre-marked as Exhibit 5, which is Cardi 313 through 314, referring to the base numbers at the bottom of this page. Do you see that number?
Okay. Cardi underscore 000313.
Yes.
That is correct.
I said Exhibit 5 marked for identification. Question. Now, do you see there are two email strings here? His answer, yes. The first one meaning question. The first one meaning the one on the lower portion of the page that's split between 313 and 314 is from Jamie Barata at Davis Shapiro. Do you see that? His answer, yes. It says, my question, it says, please see the attached time-sensitive cease and desist letter on behalf of Damian Granderson. His answer, yes. Question, okay. And then you see above that on September the 20th, there's a response from TashaKBusiness@gmail.com. Do you see that? His answer, yes. My question, did you send that email? His answer, no. My question, the one on September the 20th at 6:34 a.m. His answer, no. Question, okay, who did send that email? It could have been Tasha. It had to be. But no, I don't respond to any emails.
Oh, well, I mean, I can't.
Are you aware that that's the deposition testimony your husband gave?
Say that again?
Are you aware that that's the deposition testimony your husband gave?
Yes, ma'am.
So if he gave that testimony, you're saying that he's lying?
Yes, ma'am. Because we were both receiving emails.
Bam!
Boy, yo.
I'm sorry. I need to do that reaction, y'all,
Yeah,
but
that just scared the hell out of me.
I'm sorry. I had to do that reaction. She
I thought
said
we couldn't
nobody
do that.
threw anybody under the bus. She just said, Does that mean your husband lying?" She said, "Yes,
Yes,
ma'am." Could
ma'am.
y'all read that part again, please?
Sure. So if he gave that testimony, you're saying that he's lying?
Yes, ma'am. Because we were both receiving emails.
Okay. Thank you. All right. Can we go back to plaintiff 683? I'm sorry, 863. All right. So your testimony is that your husband wrote this response on Thursday, September the 20th. Do you see that?
Yes, ma'am.
And then if you can go down, please, to the next page. Okay. And then after that, you received another communication, correct?
You mean after that email?
Yeah. Where it says from Damian Granderson to TashaKBusiness@gmail.com.
I've never seen this one before.
But you don't deny that that is your business email address.
That's my business email, but I've never seen this email before.
Okay. You don't.
That's not my email. My husband runs that email.
But it's the business email, ma'am.
That is correct.
Okay. And you're a co-owner of the business, correct?
That is correct.
All right. So the business received this email, correct?
My husband received this email who manages all advertising and stuff like this. Yes, ma'am. I don't have access to this email.
So if your husband testified that you did have access to the email, that would also be untrue.
That is correct. I only have access when I have his phone.
Hmm. So you do sometimes have access to this email address.
On his phone, but I do not have the password or anything to get into it.
When I asked you if you had access, do you understand the word access?
Yes, ma'am, I do.
Okay, so when you said no, that wasn't true. You do sometimes have access to this email.
When it's open on his phone, yes, ma'am.
Okay, all right. So in this email, this was a response to the email you had sent that said your email indicates a lack of understanding of the nature of defamation per se and your legal exposure as a publisher of that defamation. Do you see that?
I see that. Yes, ma'am.
Okay, and it says well, why don't we look at the response that was sent first? Can we go up a little bit? So the response that was sent responded to Damian Granderson.
You mean the please see attached portion?
The response that is sent on the second part of the page.
Dear Granderson.
Damian Granderson.
Okay, can you pull it up some, please? Thanks. Okay. So you want me to read it?
I just want you to know if you can see it now, correct?
Yes, I can see that.
Okay. So the response that was drafted on your behalf, you're saying, is that Unwind Tasha K is a celebrity gossip platform and all stated opinions are alleged. You see that?
Yes, ma'am.
And you are talking about the Star Marie Jones video, correct?
It says that in the email.
I'm asking, okay, and then it says the URL in the letter is an interview video conducted by Tasha K with Star Marie Jones giving her account while she allegedly lived with your artist, Cardi B. You see that?
I do see that. Yes, ma'am.
Okay. And then it says a little bit further down, Tasha K didn't make any statements in the interview. She asked questions and listened as any blogger, journalist, or gossip personality would. You see that?
Yes, ma'am. I see that.
And it says you should forward your cease and desist letter to the appropriate party. The video is not coming down.
That is correct.
Okay. And if your husband sent this, he was authorized to do that on your behalf and on behalf of the business, correct?
Oh, yes, that is correct.
All right. So essentially, what you're conveying is that you didn't think the business did anything wrong because you published somebody else's statements. Is that right?
I'm sorry. Can you repeat that question?
Was your position at the time that the business didn't do anything wrong or you didn't do anything wrong by posting the interview because you were publishing Miss Jones's statements?
That is correct. Yes, ma'am.
But you do understand that as the publisher, you're also responsible for the content that you publish, correct?
That is correct.
You understand that now, right?
That is correct. I understand it.
All right. So there was a response drafted to this, but you still went online and in an attempt to discredit the cease and desist to your viewers, said that it was fake, right?
Yes, ma'am.
All right, let's go down to the response to this. Okay. And so then this next portion of the email that we're looking at was in response to what you're saying your husband sent. Do you see that?
Yes, I see it.
Okay, all right. And you're saying your husband never informed you that you received this email,
I'm sorry. Can you repeat that? My husband never informed me that I sent this email.
that you received this next part of the email,
No, I've never seen this part. No,
but he never informed you about it either?
I guess not. No, I never seen it. Is there a reply to it?
I'm just asking you if he informed you of it.
Okay. No, no, ma'am.
And he didn't forward it to you.
No, ma'am.
All right. Are you aware that your husband testified on page 94 of his deposition, line 18 through 24? The question, okay. So you said, I believe you said whenever you receive a cease and desist or something like that, you forward it to her. Is that your usual custom and practice? His answer, yes. I would either forward it to her or I would let her know, depending on where it is at the time.
So what's your question? I'm sorry.
You are saying that what your husband testified to is his usual custom and practice he did not do. That's your testimony, correct?
Yeah, I did not see this part. That is correct.
Is your testimony that the Star Marie Jones video is an opinion piece?
Not really. No, ma'am. It was her account
Okay, so we can agree that you published that as what you classified as a factual story, correct?
in some parts.
All right. So the part of the response that said it's an opinion, you disagree with that, correct?
I'm sorry. Say that again.
The part of the earlier response we were looking at that said it was an opinion, you disagree with that, correct?
My statements are opinions. Yes, ma'am.
Well, I just asked you if it was an opinion piece and you said no.
No, because it was her personal account, but my statements in the interview were opinion based off of her account with Miss Almazar. So there are many different points in that interview.
But you don't think that Star Marie's statements, you're not contending that that is an opinion piece, correct?
Oh, that is correct. Yes, ma'am.
All right. If we could just scroll back up to the middle part of the response again, I just want to look at that. Okay, that first sentence, it says, Unwind with Tasha K is a celebrity gossip platform and all stated opinions are alleged. And we've just established that you are talking about the Star Marie Jones video in this email and that this email is discussing that, correct?
Well, it says all, so we're talking about it's a gossip platform. So everything that we do that Unwind with Tasha K says is based on opinion. I get third party information, so I can't state it as a fact because I'm not there. So we basically just, in this email, it looks like it was forwarded as our disclaimer that we put on all of our videos.
Okay, but when your attorney questioned you earlier about the type of content you put out, you didn't talk about that. You said, well, I take stories from sources or they're already on the internet. And of course, I investigate the stories and I publish them as either fake news or real news. Do you recall giving that testimony, ma'am?
That is correct. Yes, ma'am.
All right. So when your attorney was asking you about your business, you did not give the testimony you just gave about everything being opinion. You classified it as real news or fake news, right?
I'm confused. Could you reword that question?
Sure.
Thank you.
Earlier, when your attorney asked you to classify your stories, you did not give the testimony you just gave me. You told him that you investigate stories and you publish everything as real news or fake news, correct?
That is correct. Yes, ma'am.
All right. So you're changing your testimony a little bit again, correct?
No, ma'am.
All right. So after the business responded to this and said that all stated opinions are alleged, you created another video saying that where you told viewers that everything we said, everything the star said was accurate. Do you recall that?
That is correct. Yes, ma'am.
All right. So you didn't tell viewers that you said what you said in that letter, correct?
I'm sorry?
You did not tell your viewers what you said in this letter, correct?
It's on the bottom of every video.
It's on the bottom of every video?
Yes, if you look in the comment section at the bottom, this is something similar to this is in the bottom of every video.
All right. We'll look at that in a minute.
Okay.
But I want to know what you said in the video. Well, let me ask you this. When you go to the YouTube page, if I hit the landing page of this video right now, would I be able to see that?
Yes, it's in the bottom in the description.
Will I be able to see it on the first page?
On the first page?
Yes.
Yes, it's on the first page on the landing page. So when you click the description box, all of that comes up.
No, no, no. I asked you if I just went to a video, would I be able to see it without clicking anything else?
I'm confused
What's confusing about that? You just said,
because you just asked.
I'm sorry, can I please finish my question?
Okay, I'm sorry. I'm sorry. You're right.
You just said you click and then it's in the description. And I want to know, I'm clarifying. So, what your testimony is that this disclaimer you're talking about, I want to know if I go to the page and the video just comes up, can I see that without clicking on anything else?
No, because it's a written description. So click, when you come to the page, you click on a video and then all written text is in the bottom. It's 2 parts to complete the entire video. Sorry about that.
Right. Because if I just click play on the video and I don't click read more in the description, I will never see this disclaimer, correct?
That is correct. If you don't click that.
All right. And before the disclaimer in the text box, you have the hashtags we looked at last week, correct?
That is correct.
And you have the marketing material asking people to go to your Teespring page, correct?
But not anymore, but in that video, yes, that is correct.
Okay. And you have plugs for other equipment that you use in your advertises, correct?
That is correct. Yes, ma'am.
All right. And the part of the text box that you are saying contains this disclaimer, the part that is shown without clicking anything else, only contains the hashtags and some of your marketing material and plugs for your other products, correct?
Once you click it, it brings up the whole box.
And please answer my question.
Yes, that is correct. Once you click it, it drops down the whole box. So you don't click it twice, you click it once.
That isn't the question I asked. Could I have the question read back?
Whereupon the record was read.
Read the first part again. I'm so sorry because it was a long question. Could you read the first part for me again, Sarah?
Mm.
The top half.
The question I'm asking is if I go to the page to look at a video,
Okay.
there is a description box where, without clicking anything else, you can see part of the description. You understand that, right?
Yes, that is correct.
Okay. So without clicking anything else, the only thing I will see is the part of the description that has the title of the video, your hashtags, and your promotions for your other products, correct?
That is correct. Yes, ma'am.
Okay, thank you. But going back to my question, so if I went to this video, Star Marie Jones video, and let me ask you this. Are you sure you were doing disclaimers at the time you published this Star Marie Jones video?
That would be a question for my husband because he takes care of all that marketing material. So that would be a question for him. But this has always been our disclaimer since we started the channel.
But you're not actually sure it was on there?
I'm not sure of the exact date. No, ma'am.
Okay, sorry. If you don't mind, just let me finish my question.
I'm sorry.
Thank you. So if I went to look at this video as a consumer and I click play on the video and I did not click read more, then in the next video you made, what I would have heard is you saying everything that we said. everything that Star said was accurate, correct?
That is correct. Yes, ma'am.
All right. And you've made many other statements in the videos that we saw last week, in the videos themselves, when you're speaking, implying that what you say is real news, right?
That is correct.
Okay. And one of the videos that your attorney showed you, the lovely T call, you know what I'm talking about when I reference that, correct?
That is correct. Yes, ma'am.
And just for the jury, it's that 2 hour, almost 2 hour call that we listened to.
Yes, ma'am.
It was not a video, it just had a photo displayed.
Yes, ma'am.
And in that, you published that. And in that, you had said, quote, my shit is real effing news. You remember that?
Yes, ma'am. That is correct.
Okay. And you also recall testifying that you do tell your viewers that it's your job to report the news, correct?
Yes, ma'am.
All right. So when you convey to your viewers that what you're doing is real news and that it's your job to report the news, you are not conveying to them in those oral statements that you've said in this letter that these are your opinions, correct?
It depends on the video.
You've admitted in your deposition, though, that when you're giving opinion, you don't always, when you're giving what you think is opinion, you don't always even tell your viewers that, correct?
Could I go to my deposition to read that to see what the question was?
I'm just asking if you recall for now.
Something like that, but I don't remember the question in which I was answering.
Why don't I just ask you? When you're giving what you are saying is opinion, do you always tell your viewers it's my opinion?
Not always. No, ma'am.
Okay, thank you. So, all right. You also admit that you've made statements that are not true to your viewers about being a journalist, correct?
That is correct. Yes, ma'am.
Meaning that you've referred to yourself as a journalist in statements to your viewers, but you acknowledge that is not true, correct?
That is correct.
All right. In the video that we were talking about a couple of minutes ago, that was published on September the 21st, about 2 days after the Star Marie Jones video, do you recall that video?
Yes, ma'am.
Okay. And do you recall last week when you originally testified? I played your clip where you had said in the video, you had said that the interview was highly requested. Do you remember that?
That is correct.
And I had asked you a question about your deposition transcript. And I asked you if you recall testifying. Did you have people reaching out to you at that point asking if you could do an interview of her? Were your fans asking for that? And you had testified no, nobody asked me to. Do you recall that?
That is correct.
All right. And then when you testified here in court, you said, well, they weren't talking to me directly on Instagram or online. People would tag you and say, hey, Unwind Tasha K. It happens all the time because I'm a news reporter and they want me to follow up on the story. Do you recall saying that?
Yes, ma'am.
Okay. And you also went on to say, but if you say personally, no, no one called me or anything. No, ma'am.
That is correct.
All right. So you also made a separate statement, though, in that same video dated September the 21st, that you actually got direct messages from all the winos asking you to reach out and talk to Star Marie. Do you recall saying that?
That is correct.
So you are admitting that you got direct messages.
I mean, I got tagged. So when you, may I explain? I'm sorry.
You can just say no if it's not true.
I'm not understanding because in the deposition, you asked me a different question. And so,
No, no, no. I'm asking you now about this other statement.
I'm sorry. Say it again.
I'm asking you about this other statement. You said in the video, you told your viewers, I got DMs, which
Yes,
are direct messages, right?
that is correct.
And you said I got those from all the winos. And winos refers to your fan base, correct?
That is correct.
You said I got direct messages from all the winos asking you to reach out and talk to her. Do you remember saying that?
That is correct. Yes, ma'am.
Okay. So you are actually saying that when you said that in the video, you didn't actually get DMs. You were maintaining that you got tagged.
That is correct. Yes, ma'am. Because you can tag in the DM.
Did you get DMs or not, ma'am?
Yes, and you can tag in the DMs. So that's the same thing. So you're trying to make it two separate issues, but it's the same exact thing. So when someone DMs you or tags you, they can tag you in the DMs. So just because I didn't relay it in the video the entire way in my deposition, I'm not saying two different things. I'm actually saying the same thing.
All right, let's talk about that.
Yes, sir.
I just want to make sure the jury has not got all the vernacular. Well, I want to make sure the jury has got all the vernacular right. A direct message is a message from whoever sends it to the person they send it to, correct?
That is correct. Yes, sir.
And does it appear publicly available to other people?
No, sir.
So when you say they tagged you in the direct message that they send you, what does that mean?
It means like they can share a photo to their story, right? And so they can say at Unwind with Tasha K. They don't necessarily have to say Unwind with Tasha K. Do this story. They can let me know it's here. So there's many different ways that they can tag you in the DMs besides saying, "Hey Tasha," and we have a conversation. Can you do this interview?
Well, if they sent you a message and they told you something directly in the message, it's not available to other people?
That's correct. Yes, sir.
So tagging doesn't have the same effect that generally tagging would have on social media, where it's available for everyone to see and it would come to you indirectly. It's all directly to you.
No, because if they tag me a picture that they post to their story, everybody can see it. So just because it's coming to me individually, people can still see it on their story.
They can see the message they sent you.
They can see my ad. They can see them, "Hey, Tasha, I want to alert you about this story." So yes. So yes, it's coming to me privately, but it's still publicly available on their page.
All right, thank you.
Okay, no problem.
Okay. You also acknowledge that you have said things in recorded phone calls that are not true. Is that correct?
I'm sorry?
Did you say anything in that recorded phone call with Lovely T that was not true?
Not to my recollection. No.
All right. So in that video, we heard you say, but I didn't know that you had receipts debunking it. Do you recall making that statement in the Lovely T recording?
Yes, ma'am.
All right. And just to refresh the jury, the Lovely T recording was recorded after the phone call that you had with Lovely T the weekend that between when you recorded the Star Marie Jones video and when you published it, correct?
Yes, ma'am. That's correct.
All right. So when you made that statement in the Lovely T call, but I didn't know that you had receipts debunking it, you were referring to that weekend between the time when you recorded it and published it, correct?
That is correct.
All right. But you have admitted since then that you did know that she had information that Star Marie Jones was lying or that would counteract Star Marie Jones' statement, correct?
Yes, ma'am. That is correct.
And you also recall giving testimony that you did know that she had those receipts. You just didn't ask for them or didn't want them, correct?
That is correct. Yes, ma'am.
So the statement you made in the Star Marie, withdrawn. Let me start that over. The statement you made to Lovely T on that call when you said, but I didn't know you had receipts debunking it, that was not entirely true, correct?
That wasn't entirely, uh, that wasn't the entire point.
I'm just asking if that statement wasn't entirely true, ma'am. I'd appreciate it if you would answer my question.
How do you say it's not entirely true? Could you elaborate on that question some more?
At the time you made the statement to Lovely T that I didn't know you had receipts, did you know when you made that statement that she had receipts, or did you not know that she had receipts?
No. I knew that she had information given to her, basically counteracting that Star was a lie. So, yes, thank you.
Okay. All right. And talking about the Lovely T call for a couple of more minutes. You said, I believe, well, do you recall the first day that you testified? I asked you how far, from the time you released it in April, how far back it had been recorded. Do you recall that?
Yes, I recall that question. Yes, ma'am.
Okay. And do you recall telling me that even though you had said it was like 6 months, you weren't sure, that you felt like you had just given that answer at your deposition to get me to move on?
Yes, ma'am. That is correct.
But when your attorney stood up yesterday and asked you about your recollection when you recorded that call, you said probably 6 months after I did it.
I'm sorry?
Do you recall giving that testimony to your attorney?
No, he didn't ask me that. That's not what he asked me.
All right.
He asked me when I published the call, and that was 6 months after, which is a month after Miss Almazar had filed the lawsuit. But I recorded it sometime towards the end of September and October, which, if you do the math from that time, that's about 6 months. So I remember that question very clearly. That's not what he asked me.
Okay, so your testimony is that when I asked you from the time you published it how far back it had been recorded, you couldn't recall that. But when he asked you when you released the call or published it, you could recall that it was 6 months after you recorded it.
I'm sorry. What is your question? What are you trying to say? I'm sorry. I'm not trying to be like disrespectful or combative. I just want to understand what you're saying.
I think the point has been made. I'm going to move on.
You're sure?
Yeah, I'm good.
Okay.
All right. During that call, we heard a lot of conversation between you and Lovely T about your friendship. Do you remember that?
Yes, ma'am. That is correct.
It's
It's
not love. It's not Lovely Ti, is it? It's Lovely T.
Yes, sir. That's correct. It's lovely tea.
Oh, I'm sorry.
Right, not Ti. We don't want to bring him into this.
No, fair enough. Fair enough. Lovely T.
Yes, ma'am.
Okay, so we heard a lot of conversation between you and Lovely T about your friendship, correct?
That is correct. Yes, sir. I mean, yes, ma'am.
Okay, and do you recall testifying when your attorney was asking you questions that you testified the reason you recorded the call was because you started to see that Lovely T was, taking the side of Cardi B. So, betrayed you. Do you remember giving that testimony?
Yes, ma'am. That is correct.
So you recorded the call because you thought that your friend was betraying you.
Yes, ma'am.
Did Lovely T know that this call was being recorded?
No, ma'am.
So you didn't tell her.
No, ma'am.
Do you have any idea if her permission was required to record this call?
It was not. Georgia is a one-party state.
But she's not in Georgia, right?
No, I am. I was in Georgia when I recorded the call.
Hey, let's not argue about what law applies. Just talk about the facts.
Sure. She's in Minnesota, correct?
I believe so. Yes, ma'am.
Okay. And during that call, you were recording it for preservation purposes because you thought at some point you might need to use it. Is that right?
That is correct. Yes, ma'am.
And so you thought at the time you were recording it that at some point you might publish it, correct?
That is correct. Yes, ma'am.
All right. And during that call with this person who you have, well, let me ask you this. Were the two of you actually friends?
Yes. Yes, we were.
Okay. And did you consider her a friend at that time?
At the time that I recorded the call, yes.
Yes. That was me.
I
Yeah.
started to see behavior that didn't resemble what a friend was.
Okay. But you didn't tell her that piece of it, correct?
That is correct. Yes, ma'am.
All right. And on the call, knowing that you were potentially going to use this at some point and publish it, you brought up her personal medical information. We heard that yesterday, correct?
Yes, ma'am. That is correct.
And when you published this entire call, you did publish the entire call on the internet, correct?
Yes, ma'am.
Is it still up today?
I believe so. I believe it's privated on my channel, if I'm not mistaken. I can't remember because we go through in private and unprivate stuff on my backup channel.
All right. And when you published the entire call, you decided to leave in the parts where she was crying and talking about your friendship and where you talked about her personal medical information.
Yes, ma'am.
All right. You also admitted yesterday on the stand that you have given testimony, that you were giving testimony yesterday that was different than your deposition and what you had said earlier in this trial, correct?
Could you repeat that question? Because you keep coming in and out of the mic. I'm sorry.
Sure. Thank you.
Thank you. That's why I'm like leaning into you so I can hear you.
Is this better?
Yes, yes, much better. Thank you.
Okay. I said, and you recall giving testimony yesterday that you gave answers yesterday in court that were different than the answers you gave in either or both at your deposition or earlier in this trial, correct?
I can't, not that I know of. No, ma'am.
You don't recall the court asking you, is your answer today in court different than your answer you gave either or both at your deposition or earlier in this trial? The witness, yes, sir.
Okay, yes. That particular question, yes, ma'am.
Okay.
Okay,
So you recall saying that
I do. I do.
and admitting that.
Yes, ma'am.
Thank you. You also changed some of your testimony during the deposition at various points. Do you recall that?
I'm sorry?
You also changed some of your testimony during your deposition at various points, correct?
I elaborated on it because you wouldn't allow me to speak during my deposition.
You don't recall changing your answers?
To some questions, to elaborate, yes, ma'am.
Okay, so you didn't change your answer to anything other than to elaborate. Is that your testimony today?
It depends on what we're talking about. So, what questions are you referencing? So, I can't speak for all questions.
Well, so the question, you either answer yes or no if you can, unless you say you don't remember.
Yeah, I don't remember. So, I don't want her to feel like I'm not trying to answer. So, I'm trying to recall, so I don't recall. So if you give me specifics, I'll be able to recall and be able to talk about that certain issue, because there were so many things we went over during our direct, as well as my direct with my lawyer, and 2 days worth of depositions. And on the first day, it didn't go well for either of us, but the second day, it was very cooperative.
There isn't even a question pending. I moved to strike.
Yeah, I'm not going to do it because she did it in response to the court's question, and it's not unrelated to the question that was asked, but you can certainly continue your questioning.
Sure. All right. Why don't we look at your deposition transcript? Let's look at November the 19th.
Okay.
Let's look at lines 112.
What page?
Excuse me, page 112, line 22.
Page 112, line 22?
Sure.
Okay.
Question. Do you recall publishing comments or hashtags using the hashtag herpesB? Your answer. Yeah, I've used that before. Question. Isn't it supposed to reference my client, whether whatever tweet you are using in connection with is actually about my client or not? Answer. No, because I don't know if your client has herpes or anything. Question. Okay. And what about herpes B? You are saying that has no connection to my client. Answer. No, not at all. Is that the testimony you gave that I just read?
That is correct. Yes, ma'am.
All right. And in on page 117, I'm sorry, the quote I just read you was from your November 19th, 2020 deposition, correct?
That is correct. Yes, ma'am.
Okay. So we're going to go to page 117 of that same transcript.
Okay.
Approximately 5 pages later, line 10, question. Okay. So why is the B in herpes B not referencing my client? Because you said that one isn't referencing my client, right? Your answer. Because does your client have herpes? I don't know. Does your client have herpes? Is that the testimony you gave?
That is correct. Yes, ma'am.
All right. And then approximately 20 pages later in the transcript,
Which page?
page 140,
Okay. Which line? I'm sorry.
line 25, and I was showing you what's been admitted here as plaintiff's 943. And we can go ahead and pull that up.
Okay. I see it.
I don't see it yet. Okay. I asked you, can you tell me what this is? Your answer. This is a photo I shared, I believe on Facebook, if I'm not mistaken. And I said, done herpes B. See you in court. So, yes, that was in reference to Cardi B. Question. And then the photo that you shared is a photo of my client, right? Your answer. It is. It really, yes, it is. My question. Okay. So the reference to herpes, the use of herpes B, was a reference to our client. Your answer. Yes. In that particular case, it was.
Hey guys, can we get to the point, stop at one point because it's almost 12 o'clock?
Oh, yes, please. Oh, yeah. I didn't see that.
Absolutely.
Okay, we can stop at what, page 115?
Where are we?
Yes, yes.
Okay.
So are we finishing 115 or are we stopping now?
Yeah.
Let's stop now.
Yeah.
Just remember where we are.
Yeah. 115, top of page.
115.6a.
All right, everybody, thank you so much. It's just that it's getting late. I want to go to bed.
Yeah, you and I both. I didn't realize how
All right,
I was
guys,
getting in
good
trying to prove
night.
her.
Good night, everybody.
Good
Good
night.
night.
See
Good
y'all.
night.
All
Peace
right,
Good
good
night.
night.